So welcome to another meeting of the Belgrade Legal Theory Group. Today with us is a friend of the faculty and a personal friend whom I haven't seen live in quite a while, I think, maybe since the last World IVR Congress. Hopefully I'll see him live soon in a month or so in Bucharest. Anyway, it's a pleasure and an honor to have him, Dimitrios Kyritsis, from the University of Essex School of Law. Dimitrios' topic for today is Law in the Service of Legitimacy. For those of you who don't know Dimitrios, it's obligatory to check his great book, Shared Authority, published with Bloomsbury Harts Publishing, and he has recently edited a great book on constitutional methodology, which I also suggest that you check out. Today, he won't be sharing with us parts of his books or edited authorial. We will be talking, if I understood correctly, and I think I did, about the project that he's currently doing and about a certain interpretation of the philosophy of law of Ronald Dworkin and his comments on it. So without further ado, I give the floor to Dimitrios.
Well, thank you so much. It's great to be here in this venue, and it's great to see some old friends and some new faces as well. So Boyan is right. This is an ongoing project, and I'm really keen to hear what you think. It's also one, as Boyan also said, that has a strong exegetical component. So I engage in it. I engage quite a bit with Ronald Dworkin's theory of law. So I hope it's I hope that won't make it too boring for you. It goes beyond the exegesis, though. So I should say that this is it's so new that I haven't had a chance to practice this presentation, and so you will forgive me if it's not as crisp. But hopefully you'll get the gist of it, and I'm happy, of course, to answer any questions. Okay, so just a little bit of stage setting to begin with. So anti-positivists think that law is essentially connected with some part of morality, and for Ronald Dworkin, as is well known, that part is the theory of political legitimacy. Dworkin maintains that we ought to understand the law through the lens of its moral point, which he claims is to justify state coercion. For Dworkin, when law goes well, it serves this point by giving citizens a special political obligation to comply with it, and hence states a moral warrant to use force against them. So in this paper, what I'm doing is I'm pursuing this line of inquiry a little bit further. Now, you'll be relieved to know that I will not embark on a wide-ranging defense of Dworkin's brand of anti-positivism, rather working within an anti-positivist, an interpretivist framework. I want to focus on that connection between the theory of law and the theory of political legitimacy that Dworkin champions. I will ask, if you are a Dworkinian, how should you conceive of the way in which law contributes to legitimacy? Now, I'm going to answer this question in a bit of a roundabout way. I'll critically examine another aspect of Dworkin's theory of law. It's court centrism, as I call it. In his last, in the book that was published, in the book of his that was published before his death, Justice for Hedgehogs, Dworkin explicitly endorses a particularly strong form of court centrism. He claims that judicial enforceability of a right or duty is the touchstone of its legal character. In other words, whether we have a legal right or duty turns on whether it is possible for a court to enforce that duty or right on demand. Now, others have commented on this critically, Larry Sager, Mark Greenberg among them. I'm also skeptical about court centrism. In fact, in earlier work, Dworkin himself left open an intriguing alternative to court centrism, which his later position in Justice for Hedgehogs foreclosed. According to that alternative, there may be duties that are legal despite the fact that they are judicially unenforceable. And here I want to retrieve that alternative and build on it. But as I said, my primary aim is not exegetical. Rather, I shall claim that this alternative brings into sharp relief a dimension of political legitimacy that is largely absent from Dworkin's account. I call it the assurance dimension, or assurance legitimacy for short. Assurance legitimacy prescribes institutional guarantees that a political regime will reliably and systematically act in a morally justifiable way. That's just, I will use this formulation on a number of occasions. So assurance legitimacy prescribes institutional guarantees that a political regime will reliably and systematically act in a morally justifiable way. I'll argue that assurance legitimacy is an attractive and important moral principle, and that the law makes an essential contribution to it. Conversely, our understanding of the nature of law must also be informed by law's connection with assurance legitimacy. And equipped with this connection, we can then return to the question whether we should or not adopt a court-centric understanding of law. I will argue, or maybe I won't get to that point. But anyway, that's the claim that I want to build on this account of assurance legitimacy, that law's normative significance stretches beyond the courtroom. Some of the most consequential constraints it imposes on government are policed not by judges, but by other political officials, public officials. Right. Okay. So that's by way of stage setting. Let's get to the nitty-gritty. Now, I don't remember if you've recently read or reread Law's Empire. I did so during the pandemic. I find Law's Empire very. I found a bit of solace in Law's Empire during those long stretches being in lockdown. So here's a bit of a story about my rereading of Law's Empire. By the time we get to chapter 10 of Law's Empire, for most commentators, the fireworks have all gone off. Behind us are the big battles about the nature of legal theory and interpretation, internal and external skepticism, associative obligations, and legislative intent. In addition, most of the substantive claims about the character of constitutional interpretation that are contained in chapter 10, Dworkin has made elsewhere, and in quite a bit of detail, especially in a matter of principle. And yet, tucked away in that chapter is what I thought a striking passage. And in that passage, Dworkin sketches an alternative to a system of judicial supremacy that a legal order other than the US may adopt. Here's the passage. That's from page 355, the end of 355 of Law's Empire. The Constitution might have been interpreted as laying down directions to Congress, the President, and state officials that these officers had a legal as well as a moral duty to follow. but making them their own judges. The Constitution would then have played a very different and much weaker role in American politics. It would have served as a background for political arguments among different institutions about the limits of their constitutional jurisdiction, rather than as a source of the authority of one of these institutions, the courts, to fix those limits for the rest. End of quote. Here, Dworkin seems to be saying something that he denies in later work, namely that in a system that rejects judicial supremacy, the directions contained in the Constitution impose on the President and Congress legal duties, albeit weak, despite the fact that courts lack the authority to interpret and enforce those duties. As I'm sure you know, in Justice for Hedgehogs, Dworkin takes issue with that very same claim in the form given to it by Larry Sager. To Sager's claim that constitutional law contains some norms that are judicially unenforceable, Dworkin counters in Justice for Hedgehogs that the law just is the set of rights and duties that can be enforced on demand in court. On this account, a duty that is not judicially enforceable is just not part of the law. It may well be a moral duty, but it cannot be a legal one, which sounds like the exact opposite of what he allows on page 355, 356 of Law's Empire. Now, why should we take an interest in this issue in the first place? Scott Hershowitz, for one, views the jurisprudential obsession of policing the boundary between law and non-law as at best a distraction. However, this is not a mere classificatory issue. For Dworkin, it is first and foremost a moral issue. Its resolution turns on our proper understanding of law's moral point. And conversely, the reason why Dworkin's focus on judicial enforceability in the Hedgehog's book is mistaken, if, as I would claim it is because it hides from sight a crucial dimension of law's moral worth. I will argue that we must take a more expansive view of that moral worth in order to appreciate what the judicially unenforceable duties that the Constitution imposes contribute to a legal order. Why, therefore, they too should be included within the law's extension. So rather than a distraction, the jurisprudential controversy about the existence of legal duties outside the realm of adjudication focuses our moral inquiry. And that inquiry leads us to revisit the theory of political legitimacy underpinning Dworkin's theory of law. Before I start, let me just say a couple of things about what it is that we're looking for. We're not just looking for a sound or the soundest or an attractive or the most attractive account of political legitimacy. We are looking for an account of legitimacy that does a good job at explaining and justifying what Dworkin takes to be the most general features of law. This desideratum is encapsulated in one of the most memorable lines of Law's Empire, where Dworkin describes the most general point of law. That's from page 93 of Law's Empire. Law insists that force not be used or withheld, no matter how useful that would be to ends in view, no matter how beneficial or noble these ends, except as licensed or required by individual rights and responsibilities flowing from past political decisions about when collective force is justified. So that's a desideratum. Our accounts of the moral point of law must explain and justify how it is that the use of the coercive force of the state is justified when it flows from past political decisions, and only if it flows from past political decisions. Now, Dworkin claims that this imperative for fidelity to the past is part of the essence of the rule of law. For him, there is a nexus between the rule of law and the theory of law. So let's call it the legality nexus. According to Dworkin, we determine the content of the law by elaborating the ideal of legality and drawing out the constraints that this ideal imposes on state action. Legality is, of course, a contested ideal. Different conceptions of legality will spell out in different ways why it is important to be faithful to past political decisions and how we ought to be faithful to them. And hence, they will delineate the extension of law differently. But for Dworkin, that's only to be expected. In any flourishing interpretive practice, there will be this kind of disagreement. Hence, the legality nexus offers no more than, quote, an abstract description, unquote, that serves to organize our debates about which conception of legality, and hence which conception of law, is superior. So that's just to give you a sense of the terrain on which I will be defending my preferred account of assurance legitimacy. What I want to show is that assurance legitimacy does a good job at vindicating the legality nexus, at explaining and justifying why the content of the law should be sensitive to past political decisions. But just to give you an example and to make some progress with the argument, you can see the legality nexus at work in Dworkin's own preferred elaboration of the moral point of law, law as integrity. Recall, a political community exhibits integrity when it treats all citizens according to the scheme of moral principles that it had committed to in the past, whether or not that scheme is morally optimal, provided that it fits, quote, a plausible conception of equal concern, unquote. Now, thus understood, integrity builds a strong connection between the law and the legitimate use of state coercion. Integrity demands that we interpret past political decisions in order to specify which moral principles those decisions presuppose and endorse. In other words, which moral principles we had committed to as a political community when we made those decisions. And then integrity asks us that we apply those same principles in future cases. So in so doing, integrity achieves a kind of equality among citizens, which arguably makes the law worthy of their allegiance. So we've got in this in law as integrity all the elements that we would expect to find in a Dworkinian account. So we've got a value, an egalitarian ideal, the value of integrity, and that ideal prescribes that we pay attention to past political decisions. Why do we need to pay attention to past political decisions? In order to glean from them the principles, the moral principles that our community had committed to in the past, so that we can apply those principles in future cases. Now, if you think that integrity is the master value of law, it would seem like a short step away to also embrace court centrism, with its emphasis on judicial enforceability. Here are a couple of reasons why it would be a short step. First, as Dworkin puts it in Hedgehogs, courts are, quote, institutions that direct the executive power of sheriff or police, unquote. So courts direct this power to enforce certain individual rights, such that enforcement of these rights is directly available to aggrieved individuals upon demand. So we've got the element of coercion here, the connection with coercion. Second, it is common to think of judges as under a special institutional duty to decide cases in accordance with pre-existing law. And it would seem that integrity requires of judges to do just that, to decide in accordance with pre-existing law. Hence, we have the connection with judges. So there is a story to be said then, which issues from integrity, which leads us from integrity to judicial enforceability. But is that the best way to understand how law justifies state coercion? Here are some doubts. In the rendering of integrity that Dworkin put forward in Justice for Hedgehogs, what is crucial for legitimacy is the point at which a right or duty may be enforced by a court upon the demand of a litigant. It asks how the existence of moral disagreement configures the conditions for legitimating the exercise of state coercion at that point. I've called this in the book that Boyan mentioned in the beginning, the retail level. Now, clearly, it's part of the moral problem of state coercion that we can sometimes enlist courts to coerce others at that retail level. So it matters a great deal under what conditions this can happen. Also, there's no doubt that law has a lot to say about that retail level. But state coercion poses a moral problem long before we get to adjudication and the enforcement of retail rights and duties. As Nikos Stavropoulos has put it, when we live under a political regime, quote, coercion by appeal to institutions is always on the cards, unquote. And I would add, so is the risk that political institutions might decide to use their coercive power wrongly. This is a standing risk and calls for guarantees that I call systemic, that a political regime must provide ahead of any particular disputes. For instance, it must guarantee that there will exist judicial institutions as we know them, impartial and professional in the long run, and that they will not be abolished or staffed with cronies. So these are systemic guarantees, and they stand at a certain remove from the retail level, the level at which a judge decides how past political decisions bear on a certain dispute. The point of systemic guarantees, such as judicial independence that I've just mentioned, is to provide legal subjects with a crucial assurance, namely that the standing coercive power bestowed on the state will be reliably and systematically used in a morally justifiable way. Tim Scanlon has used this idea of assurance in his work on due process from the 70s. He writes, quote, beyond the requirement of institutions that the power that they confer be morally justifiable, there is the further moral requirement that there be some effective guarantee that these powers will be exercised only within the limits and subject to the conditions implied by their justification, end of quote. Scanlon in that paper contends that due process is such a guarantee, and he says very instructively that due process, quote, aims to provide some assurance of non-arbitrariness, end of quote. Now, just to make it clear, assurance for Scanlon and also for me is not to be understood in a psychological sense. The way I'm using assurance, we can only say that it exists when, that's from Scanlon again, there is reason to believe that de facto power will not be exercised in unjustifiable ways, end of quote. So the claim that I'm making is when the state gives us systemic guarantees, it furnishes us with such a reason. It furnishes us with a reason to believe that de facto power will not be exercised in unjustifiable ways. Now, let me just add a couple of things about how I understand systemic guarantees. In order to be effective, these guarantees cannot be ad hoc. The polity must commit to them durably and in a way that makes reneging from them more or less difficult. Unless this is the case, unless they are durable or obdurate, to use Larry Sager's term, the reasonable thing for legal subjects is to hedge their bets, to free ride, rather than submit to the polity, lest the terms of their submission change unfavorably along the way. The systemic guarantees I have in mind typically pertain to the process by which official decisions are made. Some of them stipulate that for a certain type of decision to produce an institutional effect, certain procedural conditions must be met, where satisfaction of those conditions makes it more likely that the decision will be morally justified. For example, norms safeguarding judicial independence that I've just mentioned, norms about judicial appointments or recusal, they would fall in this category. Norms about public participation in decision-making would also count as such a systemic guarantee. But just to be clear, I do not think that assurance legitimacy draws too sharp a line between a procedure and substance. Sometimes passing a procedural hurdle requires that a decision be deemed to have a certain content. This is the case, for instance, in legal orders that have a system of judicial review of government action for conformity with the Bill of Rights. In those legal orders, a piece of primary legislation may be robbed of its institutional significance if another body, a court, finds that that piece of primary legislation is substantively defective. It violates a fundamental right. So here procedure and substance are combined. We have a procedure, sure, but that procedure makes reference to substantive considerations. So this is just to say that to my mind, assurance legitimacy does not issue in a monolithic proceduralism. Now, if you've followed me thus far, then I hope you will also agree that assurance legitimacy takes us beyond court-centrism. It's the kinds of assurance that we need to attain assurance legitimacy need not be judicially enforceable. So, just to elaborate on this point, assurance legitimacy takes hold prior to judicial enforcement on demand, and hence it is no surprise that many of the systemic guarantees it recommends are not in the court's keeping. Consider, for example, the question whom the Queen may appoint as Prime Minister, or whether the conditions for impeaching the US President have been satisfied. All these issues are relevant to assurance legitimacy, and they're also commonly treated as non-justiciable. Courts are not supposed to adjudicate disputes about whether the Queen appointed the right person as Prime Minister, or whether the conditions for impeaching the President have been satisfied. But that doesn't mean that they're insignificant. Quite the opposite. They're so significant that we think they can best be safeguarded by institutional actors with political clout, rather than bodies whose power is next to nothing. Okay, so this is what I wanted to say about assurance legitimacy, I've tried to show that assurance matters for legitimacy. Political legitimacy partly depends on whether a political regime provides guarantees that give citizens reason to believe that the state will reliably and systematically act in a morally justifiable way. And I have also explained that many such guarantees are not judicially enforceable. But that's not the end of the argument. That's not the end of the story, because it still doesn't show that such judicially unenforceable guarantees create legal duties. Dworkin may well concede the existence and importance of assurance legitimacy and still doubt that it pertains to the content of the law. After all, he never disputed that there's more to legitimacy than what the law contributes to it. So now we'll briefly turn to show why assurance legitimacy is indeed part of the moral point of law. And to do that, I need to go back to the legality nexus. I need to explain how assurance legitimacy vindicates it. I need to show that assurance legitimacy, like integrity, requires that the use of state coercion be governed by past political decisions. I'll give you two reasons why I think assurance legitimacy is indeed connected with past political decisions. At the most general level, assurance legitimacy recommends certain procedures. Inasmuch as a political decision follows those procedures, it satisfies some of the conditions of assurance legitimacy, and to that extent can rightly command the allegiance of legal subjects. So when a regime acts in accordance with assurance legitimacy, that is part of the warrant that it needs to act legitimately, and hence the decisions that it makes in a way that conforms with the dictates of assurance legitimacy are also legitimate. So therefore, they can affect our legal rights and duties. So we have here one connection between assurance legitimacy and legality. Assurance legitimacy partly explains why our legal rights and duties should be affected by decisions that have certain qualities. At a more specific level, and that's the second reason, assurance legitimacy seems to have a special connection with constitutional norms, because it's at the constitutional level that the distribution of government power is laid down and the polity's more consequential decision-making processes are designed. Assurance legitimacy takes a special interest in these matters. When, for instance, the Constitution distributes government power such that the politically victorious side is subject to controls, it enhances the regime's authority because it gives legal subjects reason to believe that they're not signing a suicide pact by submitting to that regime's authority. Moreover, constitutional norms enjoy a degree of fixity or imperviousness to change, and that, as you may recall, is desirable from the perspective of assurance legitimacy. So in this sense, constitutional norms stand for a political settlement, which is supposed to be long-term and enjoy more or less broad support. So for this reason too, it makes sense for this kind of past political decision to have the enduring impact on our legal rights and duties, as typically constitutional norms do. So when political decisions further downstream adhere to the Constitution, they uphold the political settlement that the Constitution embodies, and therefore take some of the sheen of legitimacy that the Constitution also embodies. Okay, now I've been speaking for almost more than half an hour, and I don't want to preempt the discussion. The last part of what I was hoping to present pits my account of interpretivism and normative positivism. I tried to explain there why I don't think that committing to assurance legitimacy also commits one to normative positivism, but I will leave that, you know, to for another occasion or for the Q&A, and I'm really looking forward to your questions. Thank you very much.
Thank you so much for the wonderful presentation, Dimitrios. It was it was a lot in half an hour, and it was Miodrag has already raised his hand, I think.
No.
Did you?
No, I wanted to
actually, but it looked like I raised my hand. But I can pose a question afterwards, and I will give the floor to guest of the seminar. So nobody else is coming with a question. I will join later. So.
Okay, the floor is definitely open for questions. So you can unmute yourselves directly, or just raise your hand, whichever one you like.
Hello. Shall I take the initiative to make a start? Okay.
Yeah, definitely.
Hello, everyone. Thank you very much, Boyan, for hosting this. Just to introduce myself, I'm Triaguvas. I've known Dimitrios for many years. So here's my question. I wonder whether you would be willing to take on board the following analogy that I will just very sketchily articulate in the following way. That integrity is to justice, so from a Dworkinian perspective, so integrity is to justice what assurance is to legitimacy, in the sense that there seems to be a coercion problem that touches upon both questions of justice and also questions of legitimacy. That's why we can also talk about just coercion and also legitimate coercion and mean very different things by them, correct? So I wonder whether integrity and assurance are actually ways of further spelling out concerns of justice in the case of integrity, concerns of legitimacy in the case of legitimacy. And then the question is, when you talk about the bearing of these different considerations on legal rights and legal duties, is this bearing always manifested at the level where the content of legal rights and duties is specified, or is there another dimension of these rights and duties where this bearing appears? So, for example, they are normative force, so not the content, but their force, or something else. Thank you so much, Dimitrios.
These are wonderful questions, and you won't be surprised to hear that I'll need to think more on both of them. But let me just give you a couple of first impressions, first reactions. So concerning the relationship between integrity, justice, assurance, and legitimacy, I'd say I'll need to hear more, because there are ways in which integrity is closer to legitimacy than to justice. So let me give you one or two examples. Integrity for Dworkin, and I think rightly so, is part of the answer to the problem of moral disagreement. So, we disagree about what's just, and because we disagree about what's just, but we still need to exercise coercion. What we can offer our fellow citizens is that we will all be subjected to the same standards. And I think this preoccupation with moral disagreement is also very much present in my account of assurance legitimacy. And I think it's, and I think it's, I'm not reinventing the wheel here. Disagreement is one of the, or responding to the problem of moral disagreement is one of the key dimensions of any account of legitimacy. So in this sense, I'm not sure if the analogy would work perfectly, but I'm sure there are ways in which there are things that I'm missing on regarding the analogy. Regarding your second point, I think that I think that's very, very promising to think of that bearing in ways other than or to see it play out in other ways, and not just by determining the content of legal rights and duties. I think I'm very, very. I find this suggestion very, very congenial. I don't have much to say about this because I haven't quite haven't thought about it. But unless you you tell me that I've just stepped into a trap, I think
I haven't even given it a thought either. I'm just, the thing is that, I mean, there are moments even in Dworkin where, he switches between, let's say, interpretive questions have to do with the determination of the content of rights, and questions regarding their, the overriding effect of their enforceability, let's say.
yes,
So
yes.
I
No,
think
yeah,
that.
I think you're absolutely right. It's I mean, Dworkin didn't say much about the moral force of legal rights and duties, but he did allow that because of their moral force, they might get overridden by other moral considerations. So clearly, there's room there to say things without even straying outside the interpretivist framework. Thanks.
Thanks for the question, Tria, and for the reply, Dimitrios. Paolo Sandro is also with us, and he raised his hand. So go ahead, Paolo, unmute yourself. Feel free.
Thank you very much, and good afternoon, everyone, and hi to all the attendees. So, if I may, thank you, Dimitrios. I think this is going to become a conversation that we're going to have in the near future. So I have two questions and one potential alternative suggestion for alternative reading. I'll start with the latter one. The passage at 355 in Law's Empire that you mentioned. I'm just playing devil's advocate here. Is it possible that Dworkin is not advancing? I'm not a Dworkinian, but I'm doing Dworkin exegesis right now. Is it possible that Dworkin is not advancing a normative argument, but is actually basically making a counterfactual about how the US system could have been? So I'm just wondering, because you well captured the fact that this seems very different from, from what comes around it. I'm just wondering whether it is more of a counterfactual. And the questions are, the first one is whether or not the account you develop, and particularly the idea of and the role of assurance legitimacy, is on the ideal theory plane, or whether it would depend on the institutional contextual features of So similar to Waldron's argument for, the court case. So whether or not, it depends also on the institutional background in a given system. And then the second question, and I apologize for making for the three, and the second question is about, I don't think there is a doubt that, we can have legal rights that are not enforced, because enforceability will depend on, again, the institutional makeup of the system. So I wasn't sure whether your claim was that even if there is a institutional framework for rights enforceability, you are saying that, and I think that's what you're saying, but I just wanted a clarification, that it would be better if courts were not to be involved with certain ones. I think this is what you're, so I might stop here because I think it was just a clarification, basically. Thank you.
Thanks so much, Paolo. I do think that this is going to be an ongoing discussion as we try to make better sense of each other's position. Let me just say that for me, you're absolutely right on your reading of the passage on 355, 356. I also think that Dworkin here is making a counterfactual claim, but he's making a counterfactual claim about legal rights and duties. That is the bit that I'm interested in. And then the reason why he's making the counterfactual claim is because he then wants to see what are the conditions that had to be different for that counterfactual claim to be true. He talks about, the later in chapter 10, he talks about Marbury and how it's put the American system on the judicial supremacy track, and he has a story about the kinds of circumstances that that make it the case that, for example, in the US, the whole of the Constitution, the whole of constitutional law is judicially enforceable. My interest is with the counterfactual is because it seems to entertain the possibility that if circumstances were different, there would be legal duties, albeit weak ones, that are judicially unenforceable. Now, concerning so your second point was about Waldron, ideal non-ideal theory, right? Or is that the third one? The second. So my hunch is that we are talking about that this has to be done at the level of non-ideal theory. So or it will include a lot of non-ideal theory as well. And part of the reason, I think, is precisely that so much of what counts as an assurance will be context sensitive. So, a certain body is reliable in this legal system, but it is unreliable in a different legal system because of political or cultural differences. But it can't just be non-ideal theory, right? So we need certain more general ideas about what is, desirable from an institutional point of view. Think about the intrinsic virtue of public participation. That's ideal. You work that out in ideal theory, and then you go out in the world and you see, oh, this body purports to offer public participation, but actually it's completely corrupt. So it can't perform that function. So you have to go you have to see what works in a context-specific way. And then remind me your final point. What was your final point?
The final point was just clarification that you know, you meant that even if there is an institutional framework, you think that in some cases there shouldn't be judicial enforcement of certain and.
Yeah. So yes, that's a good point. I should say that I'm not. I'm making a claim in legal theory, not a claim in normative institutional design. So I'm not saying that legal duties should or should not be judicially enforceable. The reason why I'm interested in judicially unenforceable duties is because it helps me capture the contrast between law's integrity and my approach. Law's integrity, at least as traditionally conceived, cannot explain why there could be legal duties that are judicially unenforceable. My account of assurance legitimacy can. So it's at the level of the theory of law, it's a nice example that illustrates the contrast. But I don't have, as a normative matter, I have my ideas about whether and to what extent judicial enforcement is desirable. I don't think that, for example, that judges should have a say in whether the Queen has appointed the right person as Prime Minister. But I'm not advancing a normative claim in this sense in this paper.
Matthias Bodig has raised his hand. Feel free to unmute yourself, Matthias.
Thank you very much. Nice to see you again, Dimitrios. I agree on most of the crunch points as I normally do. But my question is more a clarificatory character. When you talk about assurance legitimacy, this whole concept, the way it is constructed, I assume that it depends on a democratic form of governance. And if it does, are there any limitations on the kind of democracy that we should think about?
No, great question, Matthias. So I don't have a fully worked out answer, just to be clear about this. I don't have a fully worked out answer to your question, but my hunch is that that there could be that assurance legitimacy could be present in non-democratic regimes. And then the question for me and for others who embrace assurance legitimacy is, at what point does the lack of democratic legitimacy, undermine any gains, moral gains that we make through adherence to assurance legitimacy. Another question that perhaps is more central to my project, but again, I don't know how a fully worked out answer to it, is to what extent, and maybe that's in the back of your mind, to what extent is a certain commitment to democracy part and parcel of assurance legitimacy? Now, to that, I have an answer. So I actually think that democratic governance, obviously provided certain procedural conditions are met, democratic governance can contribute to assurance legitimacy. So my in saying that, I've been heavily influenced by the defense of democracy offered by Kelsen. So Kelsen says we care about say majority rule because it actually makes life much more palatable, political life much more palatable for the minority as well. And I would agree. If you say that many of the most important political decisions in our political community are up for grabs, such that if you get enough political support, you can change them. You may be in the minority now, and you may have to subject yourselves to norms that you disagree with, but gain enough support and you'll be able to change them. I think that makes the medicine much easier to swallow. And I guess that goes back to Paolo's point. That's well and good in the abstract, but there has to be a real prospect. No, those forms of democratic governance have to be genuine. Otherwise, you don't really provide an assurance to people when you say, oh, just go and get enough support. And so we really need to take a context-sensitive look and see if this or that form of democratic governance is genuine and does offer this genuine forum of political contestation. It might not, in which case it falls foul of assurance legitimacy.
Dan Pavlovich?
Maybe the guys want to finish their conversation.
Well, the conversation never ends, but I want to hear new questions as well.
Thank you. Well, in comparison to the previous ones, mine will be almost generalistic. Would you say that European courts have been showing too much deference to political branches of government in Europe, particularly in comparison to the role of courts in the American politics? From my perspective, it sounds that almost every political decision can pass the judicial control at the moment. I'm particularly speaking from the point of migration rights.
When you say European courts, you mean
various in various national courts, not European Court of Human Rights?
Listen, it's legitimacy, and I'm not the only one to say this. Legitimacy is not an all or nothing thing, and that's the first thing to note. And the second thing to note is that legitimacy is not undermined every time a political regime makes wrong decisions. That's part of our thinking about legitimacy, that a state can be legitimate even though it makes moral mistakes every now and then. And the same could be said, I think, or the same kind of reasoning might be employed to deal with your example. So you might say that's the European courts, say constitutional courts, have a weak spot when it comes to migration rights. Now, if you think that, and I'm happy, for example, to say to use your example, that they're making the wrong decision. That in itself does not undermine the overall legitimacy. It might make those states that have those courts less legitimate, perhaps, but it doesn't necessarily undermine their legitimacy wholesale. It might also say something about the effectiveness of this kind of control. You know, it might say that, you know, when you ask the question, is the existence of this court going to offer us a guarantee that our state will act reliably and systematically in a morally justifiable way? Then you might say, yes, in many respects, but not in migration rights. All these judgments are I think, be accommodated in my scheme. I should say this, that deference is quite central to my thinking about assurance legitimacy. One of the best things that political regimes can do to bolster their assurance legitimacy is by having a separation of powers. Separation of powers requires that one body actually lets the other bodies do their work, right? Do their thing. So in this sense, we need deference. We need deference. So I'm not one to say if the political branches make the wrong calls on immigration or economic policy, let the court step in. No, I think that would be bad. That's something that we should be skeptical about. Why? Because we need courts to have a sense of where their institutional responsibility ends, and beyond that, they should be prepared to defer even to mistaken decisions by other bodies.
Okay, now I will use the opportunity to first of all to say hello to you, Dimitrios. It's really great to see you in this seminar, and basically I don't want to contrast or criticize any of the things that you mentioned. I would like to try to, in a way, reframe the talk that you did by putting three questions, which are, to my mind, entirely different questions, although, again, to my mind, at each one of them, one may respond in positive. So the first question would be, is Dworkin wrong in thinking that judicially non-enforceable rights and duties are not law? And I would say he is plainly wrong. I mean, this goes against the basic intuitions of a number of lawyers, starting from the private law examples, you know, like natural obligations that account as legal rights, up to the constitutional rules that you are focusing on. Then the second question would be, is Dworkin's theory more vulnerable if he is forced to abandon court centrism? And I would say again, yes, although I know that you are trying to somehow basically to provide him a sort of a rescue with what you are doing. And then the third question, which is related to the second one, would Dworkin's theory be better off in certain institutional setup in which judicial enforceability is provided even for some of the assurance legitimacy practices? And again, my answer would be yes. And this would probably be European context in which you have the supranational court, European Court of Human Rights, which basically does enforce some of the, at least I can figure out some of the things that you are speaking about, which comes to this package of assurance legitimacy. For instance, they have the standard for what counts as a law, especially if this law provides you with a criminal sanctions. So it's not enough that it is passed in the parliament, but it has to provide some sort of guidelines for the subject, or a number of safeguard mechanisms for the fair trial and so on and so forth. So within these three questions, I can see that you would concede to the first answer, but that you are trying somehow to, regardless of this institutional setup, to show us that Dworkin can be rescued with this assurance legitimacy. And I would say that the way how you proceed, and we only heard a part of the argument, I would say that you're on the right track, because there is obviously a huge moral significance of what you are calling assurance legitimacy practices, and having in mind the main tenet of Dworkin's theory, I would say that I mean, you are probably on the right track, but I'm looking forward to reading this whole package of yours. So it was more of a comment. Thanks.
Miodrag, thank you. And let me just, I mean, I'm very heartened by the fact that you find that, you know, for a Dworkinian, I'm doing, I'm helping the interpretivist cause with my argument. I would like to say, just to reinforce your point, that one of the ways in which assurance legitimacy will play out is by urging us to include an ever broader network of institutions doing assurance legitimacy stuff. And I actually think that you're absolutely right, that when a transnational form of legal scrutiny is, you know, sufficiently robust, then it can actually play a massive role, a massive role to support assurance legitimacy, or to increase assurance legitimacy. And let me just say, because I think your question touched on an important substantive issue. One of the things that I bother me, let me preface this by saying that which chapter is it? Chapter 8. Dworkin's discussion of associative obligations is one of my favorite parts of Law's Empire. But I've always found it troubling that his discussion of the moral point of law is so not just court-centric, but state-centric. And I think that one of the things that people who follow Dworkin's theory should do is come up with accounts of legitimacy that, you know, do not tie the law so tightly with the existence of a community bound up in the way that Dworkin thinks an associative, a genuine community binds its members. So I think that assurance legitimacy has this advantage as well, that it helps us look at ways in which the law contributes to legitimacy, even though the bodies that produce it do not enjoy that kind of strong connection with a national community. So I'm very, very sympathetic to your suggestion. I should say I think that goes to your second point. I should say that if I'm right that assurance legitimacy is part of the moral point of law, then it will be present not only in cases where we have a judicially unenforceable right or duty, but in all other cases as well, right? So that goes back to the point that I made in my reply to Paolo. I'm interested in judicially unenforceable duties primarily because they present us with a stark example where court centrism does not apply. But I'm not, assurance legitimacy also plays a role in modulating judicially enforceable duties as well. So that's just that goes to your second comment.
Thank you, Dimitrios. As we don't have any more questions and we are running out of time, the usual time frame for these discussions is 1 hour, and quite a discussion it was. So thank you so much for presenting this ongoing work. And I thank all the participants who are here and asked the questions, especially Bram Biggs, who will be joining us in a couple of weeks on the 6th of June for the very same Belgrade Legal Theory Group meeting. So hi to everyone, and thanks to everyone, and thanks to Brian for joining this week. It was a pleasure having this conversation with you, and hopefully we'll see each other soon live.
Thanks so much. Thanks everyone. That was great. See you soon.
See you soon.